Okay, let's unpack this. Imagine like a scene straight out of a movie almost. It's late at night, a hotel lobby, pretty quiet, maybe just the wind outside, and suddenly, bam, the door bursts open. Three armed guys storm in, faces hidden, like really basic disguises. Think T-shirts or pillowcases pulled right down. They're shouting, demanding cash, waving weapons around. Now, you'd think these days with CCTV everywhere, figuring out who they were would be simple. Just hit rewind, right?
You would think so.
But sometimes, even with that footage, seeing just isn't enough. Sometimes those masks, they hide more than just faces. They hide identities. And the law, well, the law has to figure out what kind of help it actually needs to see behind them. Welcome to the deep dive. This is where we take your sources, all the articles, the research, the case notes, and we really unpack the crucial details, giving you that shortcut to being properly informed. Today, we're diving deep into an Australian legal saga. It's the case of Honeysett versus the Queen, usually cited as Honeysett VR. It started quite violently with an armed robbery, but it spiraled into this really complex, fascinating legal battle that went all the way up to the High Court.
Australia's highest court, yeah.
And it fundamentally changed how courts look at certain kinds of expert evidence. Especially, when experts claim they can identify people from really grainy, obscured images. The source material you've given us for this deep dive, it paints a pretty vivid picture. You've got the drama of the crime itself, the quiet determination of the investigation digging away. Then there's the man who finds himself right in the middle of it all, in the crosshairs. And the surprising twist when evidence that sounds scientific becomes the absolute battleground for the whole case.
Mm-hmm.
So our mission today, understand the crime, get a sense of the accused, dissect that controversial evidence used against him, and trace the case's incredible journey through the Australian court system. We'll follow it step by step.
Including who was who in the legal teams.
Exactly, noting who was fighting which corner at each stage. And then finally, we'll explore the lasting legacy of Honeysett VR and why this case, well, it's still shaping legal practice today. Okay, so let's really set that scene. This wasn't just any old robbery. It was a targeted strike, seems like, on the Nerbean Sands Hotel, just north of Sydney. This was back in September 2008. Picture it. It's late, the doors are shut to the public. Inside, staff are just finishing up their shifts. Suddenly, three men forced their way in.
And they were prepared, clearly wanted to hide who they were.
Yeah, witnesses described them wearing, white T-shirts or even pillowcases just pulled right down over their heads, hiding their faces, combined with dark clothing.
Effective, if crude.
And they were armed. Specific weapons were noted.
Mm-hmm.
One guy carried this really distinctive pink-handled hammer. Another had a shortened shotgun. And the third just had something long, maybe a pole or a crowbar. The witnesses weren't sure.
Right.
They managed to grab about $4,800 in cash from the hotel safe or tills, and then they were out, fast.
What stands out straight away from that description is the mix. You've got these seemingly quite basic disguises, T-shirts over the head, but then there's this layer of calculated planning underneath. Pulling a shirt over your head might seem amateur, but it works, doesn't it? Especially in bad lighting or with low-quality cameras, it hides the key features.
Yeah.
And the choice of weapons suggests intent. And critically, the quick escape in a specific type of car, an Audi RS4 that signals they had a getaway plan ready, it points to, well, a bit more sophistication than just a random act.
And that planned getaway, it turned very quickly into a high-speed chase. Senior constables Papalo, Allen, and Haley were out on patrol, spotted the car matching the description.
Right place, right time.
They hit the lights and sirens, initiated a pursuit, tearing through the streets late at night.
And it was during this chase, this really intense pursuit, that maybe sheer luck or maybe just good police work plus technology gave them a crucial early piece of evidence. It linked that specific car directly back to the crime scene descriptions. As Senior Constable Haley was chasing the Audi, it flew past a speed camera.
Ah, the classic speed camera flash.
Exactly. And that flash captured a photo. It later became Exhibit F in court. Why was this one photo so vital? Because it clearly showed a passenger in the fleeing Audi wearing a white head covering.
Wow.
Starkly corroborating what the witnesses back at the hotel had said about the robbers' disguises. It provided this direct physical link. Fleeing car, disguise, robbery. all connected.
But the Audi still got away that night.
It did, yes. Managed to evade capture in the chase.
Yeah.
But the police, they didn't give up. They kept looking for that specific car.
And the trail of that distinctive gray Audi RS4 eventually led them to find it. But it took a couple of months.
That's right. Recovered in November 2008. And it was confirmed, yes, this was the exact vehicle stolen from a Mr. Michael Curtin just days before the robbery.
Okay. And inside the recovered Audi, the police found something else important.
They did. They found Mr. Curtin's original number plates, the XXX77Z plates, the ones that should have been on the car, but they weren't on it during the chase.
Because the robbers had swapped them.
Precisely. This detail about the plates, it just adds another layer to this picture of premeditation. The plates they were using during the chase, AZF-16B, they'd been stolen separately. Not from Mr. Curtin's car, but from a completely different person. A Mr. Barry night, the night before the robbery. Swapping plates, it's a classic move, isn't it? Buys time, makes the getaway car harder to trace immediately.
Right. Standard procedure for pros.
And the police managed to tighten that circumstantial net even further. They presented evidence showing that only one Audi RS4 sedan, that specific model, was reported stolen in the entire state of New South Wales during the whole of 2008.
Just one. Wow.
Just one. So you've got this unique vehicle, stolen plates put on specifically for the crime, a speed camera photo confirming the disguise linked to it during the escape. The picture of what car was involved was becoming incredibly clear.
Okay, so the investigation is painstakingly building this case, based on the car, the chase, the descriptions, and eventually it leads the police to focus on one person, Anthony Charles Honeysett. He's subsequently arrested and charged with armed robbery. Specifically, the police allege he was the first offender, the one the witnesses saw carrying that memorable pink-handled hammer.
And right from the moment he's charged, Mr. Honeysett enters a plea of not guilty.
Which immediately sets the stage.
It does. It signals the challenge the prosecution, the Crown, is facing. Because, as you said, there's no direct eyewitness ID. None of the hotel staff, confronted by masked men in that terrifying situation, could point and say definitively that was Anthony Honeysett. So the Crown's case, it's going to have to be purely circumstantial, built piece by piece, inference by inference from all this indirect evidence.
Which means for the jury.
For the jury, weighing the significance of each individual piece becomes absolutely critical. Every bit of evidence, from the car trail to, well, the DNA we'll get to, had to point convincingly towards Honeysett, or the whole case could fall apart.
And this is exactly where the prosecution brought in what they clearly hoped would be the knockout punch, the most compelling, maybe even irrefutable piece of their puzzle, the DNA evidence.
2 key samples.
Right. First, found on that pink-handled hammer, the one recovered at the scene.
Yes, Mrs. Vivian Bealby, she was a forensic biologist. She testified for the Crown about the DNA profile they got from swabbing that hammer. She stated quite unequivocally that the profile matched Anthony Honeysett's DNA profile. And the statistic she presented alongside it was, well, incredibly powerful, designed to convey almost absolute certainty.
Wasn't it?
The chance of that profile matching someone else, someone unrelated to Honeysett in the general population, was less than 1 in 10 billion.
1 in 10 billion.
Those are the kinds of numbers that just scream guilty to most people listening in a jury box. It suggests it's almost impossible for it to be anyone else.
Okay, but hang on. If you're Honeysett's defense lawyer, you're looking at the evidence, maybe the CCTV stills, showing the offender was wearing gloves. So you immediately jump on that, right?
Absolutely. That's the defense's immediate, obvious line of attack. Hold on, they'd say. If the offender was wearing gloves, how did Mr. Honeysett's DNA, his skin cells, presumably get onto that hammer? They would suggest it must have happened at some other time, maybe completely innocently, maybe he handled it weeks before, totally unrelated to this crime.
A plausible explanation, perhaps?
A challenge, certainly. Something the Crown needed to address.
Okay, so that's one piece of DNA challenged. But the Crown had a second piece, also seemingly linking Honeysett directly to the crime scene, or at least the getaway. This was found on one of those white T-shirts recovered from the getaway car.
Oh, the Audi. Yeah.
The shirts that matched the description of the robbers' head coverings.
Yes, Mr. Clinton Cochran, another forensic biologist, gave evidence about DNA found on the inside neck area of that T-shirt. And again, the DNA profile matched Honeysett's. And again, the same staggering statistic was presented. Less than 1 in 10 billion chance of a random match.
But this time they had something extra.
Yes, Mr. Cochran added a crucial detail. It seemed designed specifically to counter that defense argument about innocent secondary transfer. He testified that the quantity of DNA found on the T-shirt was inconsistent with it just having, say, rubbed off briefly onto the shirt from something else Honeysett touched.
So not just a casual transfer.
No. The amount found, he testified, suggested a more direct, substantial transfer, consistent, for example, with someone actually wearing the shirt, possibly as a head covering, leaving more cells behind.
Okay, so the Crown now has this incredibly powerful forensic package. DNA linking Honeysett to the weapon at the scene, DNA linking him to the disguise in the getaway car, backed by these astronomical statistics, and expert testimony arguing against innocent transfer for the shirt. How does the defense possibly counter that, especially when Honeysett himself is saying, I wasn't there, I wasn't involved?
Well, this is where the defense introduced a really fascinating, culturally specific narrative to try and explain the presence of the DNA. Mr. Honeysett himself took the stand. He testified, denying any involvement in the robbery, point blank. He did concede that the T-shirt, described as medium-sized, probably would fit him, but he denied owning it, denied ever having seen the pink-handled hammer before.
So how did his DNA get on them?
To explain that, his defense team called Mr. Lyle Monroe as an expert witness. Mr. Monroe wasn't a scientist. He gave evidence about the social context, specifically the living arrangements and the communal sharing culture prevalent in the block area of Redfern and Sydney. This was an area where Honeysett's father lived and where Honeysett sometimes stayed. Mr. Monroe described the situation of extended family living, where possessions, clothes, tools, whatever, were routinely and freely shared among friends, family, whoever needed it. Often without much thought, without tracking whose was whose.
Wow, so a completely different kind of explanation. Not challenging the science of the DNA match itself, but offering an alternative context for how it got there.
Exactly. It creates this real tension, doesn't it? You've got the hard, statistically powerful science from the Crown's experts on one side suggesting a near-certain link to Honeysett. And on the other side, you have this culturally sensitive, context-specific explanation about how items, and therefore DNA, might easily move around and transfer within a particular community setting completely separate from the crime.
It puts the jury in a tough spot. Which story do you believe? The seemingly objective numbers, or the explanation rooted in lived experience and community practice?
It's a brilliant point of tension in the trial, and one the jury would have had to grapple with intensely. The prosecution has the high-tech, seemingly objective evidence. The defense offers a plausible, context-specific reason why that evidence might be present without proving guilt for this specific robbery.
Now, alongside the car evidence and the DNA battle, the Crown also relied on those eyewitness descriptions from the hotel staff, Mrs. Copperwheat, Mr. Sim, Mr. Nanderera. They did provide some common threads, didn't they? Describing the first offender, the one with the hammer, as having dark skin and a thin or skinny build.
They did. But, and this is so often the case in high-stress situations like an armed robbery, those descriptions also contained really significant inconsistencies, particularly when it came to height.
Right, I remember reading about that.
While Miss Copperwheat thought the offender was tall, maybe around 6 feet, Mr. Nadarera's estimate was dramatically different. He described the man as, quote, normal size for someone not big. He estimated him at maybe 5'2".
5'2".
Yes, and explicitly stated the man was a lot shorter than himself, and Mr. Nadarera was 6'4". So a very stark contrast in perception there.
And how tall was Anthony Honeysett, the accused?
His actual recorded height, noted later in the legal proceedings, was around 192 centimeters, which is roughly 6'3".
So one witness says maybe 6 foot, another says 5'2", and the accused is actually 6'3". That's more than a foot difference between one estimate and reality.
Exactly. A discrepancy of over a foot. That's the kind of inconsistency that can create serious doubt for a jury, especially when there's no direct identification possible. And it likely underscored for the prosecution, for the Crown, that they needed something more definitive, something that could bridge the gap left by these, frankly, unreliable eyewitness height accounts and the defense's challenge to the DNA evidence.
And that need for something more definitive, something scientific maybe, is precisely where the truly controversial evidence entered the frame. The evidence that took this case all the way to the High Court. Okay, so faced with these hurdles, no positive ID, those conflicting height descriptions, a plausible defense explanation for the DNA, the Crown looks for another angle. Another way to try and physically link Anthony Honeysett to the image of the offender, the first offender, in that CCTV footage.
They decided to turn to science, or what they presented as science. They sought an expert witness who could analyze that poor-quality, obscured CCTV footage and compare the physical characteristics of the masked offender with images of Anthony Honeysett taken by police after his arrest. A visual comparison, but done by an expert.
And their chosen expert was Professor Henneberg.
Indeed. And his qualifications, well, they were incredibly impressive on paper, seemingly designed to lend immense weight and authority to whatever he said in court. He held a chair, Professor of Anatomy at the University of Adelaide. His career was long, distinguished, spanning decades, different continents, Poland, the U.S., South Africa, now Australia.
Sounds very credible.
Hugely prolific, extensive publications, 7 books, something like 240 academic papers. And critically, his background included significant experience in forensic identification work going way back to the 1970s, and specifically, experience in applying anatomical knowledge to compare individuals from images, including security camera footage, since the 90s or early 2000s. He'd even done specific academic work on determining handedness, which became relevant here.
So you can imagine the impact. A witness with that kind of resume walking into the courtroom. It carries a lot of weight.
An aura of authority, definitely.
So what exactly was Professor Henneberg, with this impressive background in anatomy, the study of the human body structure, asked to do? How does that apply to looking at blurry video of someone wearing a mask?
Well, that became the fundamental question, didn't it? That was the crux of the legal argument later on. His task, as set by the Crown, was to examine that distorted CCTV footage of the first offender, a figure largely obscured by a head covering and clothes, and then compare the features and physical characteristics he could discern in that footage with photographs and measurements of Mr. Honeysett taken while he was in police custody. The goal was to see if Honeysett's physical attributes matched those visible, or supposedly visible, on the masked offender in the video.
And what specific points of similarity did Professor Henneberg claim he could actually observe through the disguise, through the poor video quality?
Professor Henneberg testified that, based on his anatomical knowledge and his experience looking at images, he could observe several features in the offender that he believed were consistent with Mr. Honeysett. He said he could tell it was an adult male. He said the offender had a skinny or ectomorphic build, he claimed. He could determine that from how the clothing hung on the figure. He estimated a medium height based on comparing the offender's size relative to fixed objects in the footage, like doorways or furniture. He noted a straight posture with what he described as pronounced lumbar lordosis.
Lumbar lordosis, that's the curve in the lower back.
Yes, a significant inward curve in the lower spine. He also claimed he could see the offender had short hair, and even that the shape of the brain case, the skull, visible from certain angles despite the covering, was elongated or dolichocephalic.
Through a t-shirt or pillowcase?
That was precisely the point the defense would later hammer home. He also said the offender had dark skin, a narrow nose root, medium eyes, and importantly, that he was right-handed, based on how he held the hammer. And then he went a step further. He didn't just list similarities. He claimed that this specific combination of features was relatively rare. He calculated its presence in only about 1.6% of the general male population.
1.6%. So suggesting it's unlikely to be just anyone?
Exactly. And his ultimate conclusion, the opinion he presented to the jury, was that he found, quote, no discernible differences between the anatomical characteristics he observed in the offender on the CCTV and those of Mr. Honeysett in the custody photos.
Wow. That sounds incredibly specific. Things like brain case shape and lumbar lordosis from grainy, masked CCTV footage, it seems. Well, almost incredible he could be that certain.
And I'm guessing the defense definitely felt that way.
Oh, absolutely. The defense vigorously challenged Professor Henneberg's evidence. They didn't just question his conclusions. They questioned his very ability to make many of those observations reliably, or even at all, from that footage. They called their own counter-experts, Dr. Sutisno, a forensic anthropologist, and Mr. Porter, who was a specialist in photographic and video analysis.
What did they say? Well, Dr. Sutisno, for example, testified that, looking at the poor footage, she couldn't even initially be confident that the offender was definitely an adult male, let alone discern specific subtle anatomical features like spinal curvature or skull shape. Both defense experts disputed Henneberg's claims that he could reliably see things like skin tone, hair length, or brain case shape through the disguises and in that low resolution. Mr. Porter, the image analyst, specifically criticized the lack of any statistical basis for the significance of the features Henneberg identified, and particularly for that 1.6% rarity calculation.
Do you question the maths?
He questioned the whole methodology. He argued that Professor Henneberg's method of visual comparison from this kind of compromised footage wasn't a validated scientific technique that was actually rooted in the science of anatomy. It was more like subjective interpretation.
So the core legal argument really crystallized around this point, didn't it? Was Professor Henneberg truly applying specialized knowledge in anatomy, as required by Section 79 of the Evidence Act in New South Wales? Was he providing genuine insights that a lay jury couldn't get themselves?
Or
Was he essentially just offering his personal, subjective interpretation of a blurry image, something the jury could look at and form their own view on, but he was lending it this false air of scientific authority because of his academic title and qualifications?
that's exactly it. The defense argued that Professor Henneberg's opinion wasn't based on verifiable scientific methods that reliably applied his anatomical knowledge to this specific task, comparing obscured individuals in poor video. They argued it was simply his ipse dixit, basically. He said it because he said it. An assertion based on his authority, not on a transparent, testable process grounded in his actual field of expertise, at least not as applied here.
So the legal system was suddenly faced with this really tricky challenge. How do you distinguish between genuine, reliable expert assistance that helps the court and potentially misleading subjective opinion that's just dressed up in scientific language?
A crucial question.
Yeah.
And one that set the stage for the case's journey through the courts.
Right. So with this highly controversial evidence now right at the heart of the case, Anthony Honeysett's journey through the Australian court system began. And it wasn't just a single trial. It involved multiple layers of appeal, each court scrutinizing the decisions made before it.
That's right. And the first really crucial legal battle over whether Professor Henneberg's evidence should even be heard by the jury took place before the trial proper even started. It happened in a preliminary hearing, what lawyers call a voir dire.
A trial within a trial, almost.
Essentially, yes. It's where the judge, without the jury present, hears arguments and decides whether a particular piece of evidence is legally admissible according to the rules of evidence. So, in the district court, the trial was set to be heard before Judge Bozic. Judge Bozic held this voir dire specifically to decide on the admissibility of Professor Henneberg's proposed testimony. The judge looked at Professor Henneberg's written reports detailing his findings, and he also viewed the CCTV footage and the custody photos of Honeysett himself. Interestingly, he didn't actually hear live oral evidence from the professor during this voir dire hearing. He relied on the written materials provided.
And what did Judge Bozic decide?
The outcome of that voir dire was that Judge Bozic ruled the evidence was admissible. He allowed it in. His reasoning, as we know from the later appeal judgments, was basically that Professor Henneberg did possess specialized knowledge, a combination of his anatomical expertise and his claimed experience in applying that knowledge to images. The judge found that the professor's opinion was based on this knowledge, that there had been sufficient disclosure of his methodology, which the judge seemed to consider was simply his process of inspecting the images, that the evidence was relevant to the case and potentially highly probative, meaning important, especially given the lack of direct ID evidence. And crucially, he also ruled that it wasn't unfairly prejudicial under Sections 135 or 137 of the Evidence Act. Those are the sections that give a judge discretion to exclude evidence if its potential to mislead or unfairly prejudice the defendant outweighs its actual value to proving a fact.
So the gate was opened. Professor Henneberg was allowed to testify before the jury.
Yeah.
And let's just pause here. Who are the legal teams involved at this initial trial stage before Judge Bozic? Who is representing Honeysett and who is prosecuting for the Crown?
For the appellant, Anthony Honeysett, his counsel at trial was Mr. Pontello. He was instructed by the solicitors, Blair Criminal Lawyers. For the Crown, the respondent, the closing address to the jury was given by a female Crown prosecutor. Her specific name isn't detailed in the source materials we have, and the Crown was instructed throughout by the Solicitor for Public Prosecutions, NSW, the state's prosecuting authority.
Okay, so the trial then goes ahead. Professor Henneberg testifies for the Crown, presenting his findings. The defense puts up their counter-experts, Dr. Sutisno and Mr. Porter, to challenge him. And Mr. Honeysett himself testifies, denying involvement and giving that cultural context explanation for the DNA. And we know from the later High Court transcript that the jury really focused on Professor Henneberg's testimony, didn't they?
Absolutely. The records show that late in their deliberations, the jury sent out specific questions directed squarely at Professor Henneberg's evidence. This indicates it was clearly weighing heavily on their minds as they tried to reach a verdict. It also confirms the view expressed later by the Crown's counsel that this anatomical comparison evidence was seen as crucial, that it carried the Crown case forwards in trying to identify the person in the CCTV footage as being Honeysett.
And ultimately, what was the jury's verdict?
The jury returned a verdict of guilty.
Guilty of armed robbery.
Yes. Mr. Honeysett was convicted. He was subsequently sentenced by Judge Bozic to a term of 8 years imprisonment with a non-parole period, the minimum time he had to serve before being eligible for release set at 3 years and 10 months.
A significant sentence. But, as you said, not the end of the legal road for Honeysett. He decided to appeal his conviction.
He did. He took his case to the next level up in the state system, the New South Wales Court of Criminal Appeal, often abbreviated as the NSWCCA.
And what does that happen? Who heard the appeal?
That appeal was heard in May 2013. The bench consisted of 3 judges, Justice McFarlane, Justice Campbell, and Acting Justice Barr. Their decision, their judgment, was delivered the following month in June 2013.
What were the main legal arguments Honeysett's team put forward to the Court of Criminal Appeal?
The primary grounds of appeal were, firstly, that the trial judge, Judge Bozick, had made a legal error in admitting Professor Henneberg's evidence under Section 79 in the first place. They argued it just didn't meet the threshold for specialized knowledge. And secondly, they argued that even with that evidence included, the jury's guilty verdict was unreasonable or couldn't be supported by the cumulative weight of all the evidence presented at trial. Essentially, that the evidence, taken as a whole, didn't prove guilt beyond reasonable doubt.
And how did the NSWCCA respond to those arguments?
The NSWCCA considered them, but ultimately they dismissed the appeal. They upheld the conviction. On that crucial issue of Professor Henneberg's evidence, they agreed with the trial judge. They found it was admissible under Section 79. They tried to characterize his evidence carefully, saying he was identifying specific anatomical characteristics rather than making a general statement of similarity or a positive identification. They were trying to distinguish it from problematic visual comparison evidence in an earlier, different case called Morgan.
Okay.
And significantly, the CCA introduced, or at least heavily relied upon, this idea that Professor Henneberg could potentially be considered an ad hoc expert.
Ad hoc, meaning for this case specifically.
Sort of, yeah. The idea is that someone might develop a specific expertise just through their intense examination of the material in that particular case. They cited some previous legal authorities like Butera, Tang, and Leung, where this concept had been discussed, although often in different contexts like interpreting tape recordings. It's also worth noting, something mentioned in the High Court materials later, that the appellant's counsel arguing before the NSWCCA, a Mr. D. Barrow, did not strongly pursue an argument that the evidence should have been excluded under the discretionary rules sections 135 or 137 based on unfair prejudice at this appeal stage. The focus was firmly on the threshold question of Section 79 admissibility.
Interesting. And what about the second ground, the unreasonable verdict argument?
On that point, the NSWCCA conducted its own independent review of the entire body of evidence that the jury had heard. They looked at the DNA on the hammer, the DNA on the T-shirt, the eyewitness descriptions with all their inconsistencies, Professor Henneberg's comparison evidence, and the CCTV footage itself. After assessing all of that cumulative evidence, the 3 judges concluded that it was sufficient, in their view, to prove Honeysett's guilt beyond a reasonable doubt. So they upheld the jury's verdict on that basis, too.
So 2 courts down the trial court and the Court of Criminal Appeal had now found Professor Henneberg's evidence was admissible and the conviction was sound. Let's just track the legal teams again. Who was arguing the case at the NSWCCA level?
For the appellant, Mr. Anthony Honeysett, his counsel was Mr. D. Barrow. He was again instructed by Blair criminal lawyers, so it seems Mr. Barrow might have taken over from Mr. Pontello after the trial or perhaps worked alongside him, but he was leading the appeal instructed by the same firm.
Okay. And for the Crown?
For the respondent, the Crown, the lead counsel, was Mr. J.H. Pickering, SC Senior Counsel. He was instructed by Ms. S. Kavanaugh from the Solicitor for Public Prosecutions, NSW. So Mr. Pickering, SC, who had been involved at trial, was retained to lead the defense of the conviction on appeal.
Right. The story could easily have ended there. Appeal dismissed. But Mr. Honeysett was clearly determined. He decided to take his case one final, very significant step.
He did. He sought, and importantly, was granted special leave to appeal to the highest court in the entire country, the High Court of Australia.
And getting special leave, that's not automatic, is it?
Not at all. It's a significant hurdle in itself. The High Court only grants special leave if it believes the case raises really important questions of law, perhaps needing clarification, or issues of significant public interest, or where there's a perceived injustice that needs correction at the highest level. This case clearly hit those marks. It raised fundamental questions about how expert evidence works, particularly under the Uniform Evidence Law, which applies across many Australian states and territories. And specifically, it brought into sharp focus those controversial concepts. What exactly is specialized knowledge under Section 79, and what is the status, if any, of this ad hoc expertise the CCA had relied upon?
So the High Court agreed to hear it. When did that happen?
The High Court heard the full appeal arguments in June 2014, and they delivered their judgment relatively quickly, just a couple of months later, in August 2014.
And the bench hearing it was the full court.
Yes, the full contingent of 5 judges available at the time. Chief Justice French, Justice Kiefel, who would later become Chief Justice, Justice Bell, Justice Gageler, and Justice Keene. The presence of the full bench signals the gravity and importance the court attached to the legal issues raised by Honeysett's case.
Okay, let's dive into those arguments before the High Court. This is the ultimate legal showdown. Who was leading the charge for Honeysett, and what was the core of their case by this stage?
Leading the appeal for Mr. Honeysett before the High Court was Mr. T.A. Game, S.C., another senior counsel, and he was joined by Mr. D.P. Barrow, who had argued the case in the CCA. They were still instructed by Blair criminal lawyers. They immediately drew the High Court's attention back to the trial itself, specifically highlighting those jury questions about Professor Henneberg's evidence. Their point was clear. This evidence wasn't just incidental, it was central, it was influential, it was likely critical to the jury reaching that guilty verdict. Their primary legal argument remained consistent. Professor Henneberg's opinion evidence should never have been admitted under Section 79 in the first place. They argued strongly that many of his specific observations, things like discerning lumbar lordosis, hair length, or brain case shape through a mask in poor quality footage, were frankly tendentious.
Tendentious meaning?
Meaning speculative, biased perhaps, pushing a particular conclusion without a solid objective basis. They argued these observations lacked any verifiable statistical foundation or scientific validation to show they were reliable or even possible under the circumstances. They really hammered home the earlier criticism from Mr. Porter, the image analyst. There was simply no established, recognized scientific methodology linking the field of anatomy to making reliable identifications or comparisons from obscured, low-resolution CCTV footage like this. Their core legal point was that Section 79 requires the expert's opinion to be based wholly or substantially on specialized knowledge. And that knowledge, they argued, must be shown to apply reliably to the specific task the expert actually performed. So while they readily conceded Professor Henneberg was a brilliant anatomist in his general field, they argued his anatomical knowledge simply didn't extend to reliably performing this particular task, comparing these images under these extremely challenging conditions. There was no scientific literature, no peer-reviewed studies, no testable methodology they submitted to support his technique here. It was, they argued, again, just his personal assertion, his ipsy-dixit.
And I believe they used that memorable analogy again in the High Court.
They did. Counsel for Honeysett brought up the analogy of the palmist again, suggesting that someone might claim to be an expert palm reader because they'd looked at thousands of palms, they'd have vast experience. But that experience wouldn't translate into specialized knowledge in a way the law recognizes, because palmistry isn't based on a verifiable, reliable body of scientific knowledge. This was used powerfully to illustrate their point. Professor Henneberg's years of looking at anatomical images didn't automatically elevate his subjective observations from this difficult footage to the level of admissible specialized knowledge for this specific purpose.
Right. Experience isn't the same as knowledge in the legal sense.
Not necessarily. Not under Section 79. They also argue that the inherent distortions in CCTV footage weren't just something for the jury to weigh up later. They fundamentally affected the science of comparison itself, making reliable measurement or observation difficult or impossible regardless of how much anatomy you know. And they strongly criticized the NSWCCA's reliance on the ad hoc expertise concept. They argued that allowing expertise to be created on the fly for a specific case loses the discipline that Section 79 demands. It essentially lets experts define their own fields without rigorous external validation.
Okay, a powerful set of arguments from Honeysett's team. Henneberg's evidence simply didn't meet the legal standard for expertise when applied to this specific task. So how did the Crown respond? Arguing to uphold the conviction. Their team was led by Mr. J.H. Pickering, S.C., who had been there at the CCA, now joined by Ms. J.A. Girdham, S.C., another senior counsel, both instructed by the Solicitor for Public Prosecutions.
The Crown, naturally, defended the admission of Professor Henneberg's evidence. They started by re-emphasizing his extensive qualifications in anatomy and related forensic fields. Crucially, they framed his evidence differently. They argued it wasn't presented as a definitive identification, nor even as a statement of high similarity. Instead, they characterized it as a description of anatomical characteristics that were observable in the offender on the CCTV. The purpose, they argued, was merely to show that, based on these features, Anthony Honeysett could not be excluded as being the person in the footage. The ultimate comparison, the ultimate decision on identity, they contended, was still left entirely to the jury.
So less about it is him and more about it could be him.
That was the argument, yes. They argued the evidence was relevant under Section 55 because it assisted the jury. How? Particularly by highlighting features that the defense's own experts disputed could even be seen, and maybe by preventing the jury from potentially overvaluing their own untrained lay observations of the footage. They referenced an English case, Atkins, where expert image analysis was deemed helpful in guiding the jury. They did concede that some features Professor Henneberg mentioned, maybe build or height estimate, might be things a layperson could observe. But they argued others, like assessing handedness, where Henneberg had specific academic expertise, having written his master's thesis on it, required his particular anatomical skill. Now, here's a really crucial strategic point that emerged during the High Court hearing. The Crown made a significant concession. They explicitly confirmed to the High Court judges that they were not relying on the concept of ad hoc expertise to justify admitting Professor Henneberg's evidence in this particular case.
They dropped that argument.
They effectively acknowledged it was, quote, a bad vehicle for arguing the validity of ad hoc expertise. They pointed out that Professor Henneberg had actually only spent about 1.5 hours viewing the relevant footage on a standard laptop. That's hardly the basis, they seem to concede, for developing some unique case-specific expertise through intense study. So they accepted the Chief Justice's proposition during argument. If the evidence wasn't admissible under the normal specialized knowledge limb of Section 79, then it was simply inadmissible, full stop. They weren't offering ad hoc expertise as a fallback anymore.
That's a major concession. What about the argument regarding unfair prejudice under Section 137? Did the Crown address that?
They did. They argued the risk of unfair prejudice here was minimal. Their reasoning was that Professor Henneberg's observations were presented as basic descriptions, not complex scientific jargon. And crucially, the jury could look at the very same CCTV footage themselves and make their own assessment of whether they agreed with his claims about posture or build. They contrasted this with other types of expert evidence, like complex DNA statistics or chemical analysis, where the jury has no independent way to verify the expert's findings. They just have to trust the expert. Here, they argued, the jury could see the raw material. So they suggested this wasn't a classic of a white coat effect, where the jury is just dazzled and blindly accepts whatever the expert says because they have a PhD. They even tried to spin it positively, arguing the evidence was beneficial because it highlighted for the jury the inherent difficulties, but also the possibilities of analyzing such poor footage, especially since the defense experts themselves had initially struggled to see even seemingly obvious things like the pink hammer or the dark skin in the video stills.
It really sounds like the High Court hearing became this incredibly focused deep dive into the very meaning of specialized knowledge and how the expert evidence rule should actually work in practice, especially with visual evidence.
It absolutely was a high-stakes examination of the foundations of expert opinion evidence.
And then, in August 2014, the High Court delivered its judgment. Unanimous, you said.
Yes, all 5 judges agreed on the outcome. They allowed Anthony Honeysett's appeal. His conviction was quashed, and importantly, they ordered that there should be a new trial.
Right. So what was the core reason? Why did the highest court in Australia definitively say Professor Henneberg's evidence was inadmissible, overturning the decisions of both the trial judge and the Court of Criminal Appeal?
The High Court's fundamental finding was that Professor Henneberg's evidence simply did not meet the requirements of Section 79 of the Evidence Act. They essentially agreed with the appellant's core argument. While acknowledging Professor Henneberg possessed undoubted and extensive specialized knowledge in the general field of anatomy, the court found that this knowledge was not the true basis, the real foundation, for the specific opinions he offered comparing the masked offender and the poor-quality CCTV footage with Mr. Honeysett. Those opinions, the court concluded, were essentially Professor Henneberg's subjective impressions or interpretations. They were observations that were not demonstrated to be based on any reliable, validated application of his anatomical expertise to the specific, difficult task at hand.
So the link between his general knowledge and this specific task was missing.
That's the essence of it. The High Court's decision really reinforced that specialized knowledge under Section 79 has to be more than just an expert's subjective belief or their gut feeling based on having looked at lots of similar things before. It must be an identifiable body of knowledge or a set of techniques that is reliable, verifiable, capable of demonstration, and based on good grounds. This echoes principles seen in other legal systems' admissibility standards, like the U.S. Daubert test for scientific evidence reliability, which Australian courts had previously referenced positively in cases like Tang. Professor Henneberg's particular technique here, visual inspection, and claiming to discern specific anatomical features through masks and poor footage, wasn't shown to be a reliable methodology that actually flowed from his anatomical knowledge in a way that genuinely assisted the jury with insights they couldn't get themselves from just looking at the footage.
And the ad hoc expertise argument.
Well, because the Crown didn't press the ad hoc expert argument strongly before the High Court, the court wasn't technically required to make a definitive ruling on whether that concept, as floated by the NSWCCA, could ever satisfy Section 79 under the Uniform Evidence Law. However, the High Court's very strict, very rigorous interpretation of what does count as specialized knowledge certainly makes it very challenging. It casts significant doubt on whether claims of expertise based merely on intense case-specific experience without a clear, demonstrable link to a broader, reliable, verifiable body of knowledge or technique could actually meet that statutory standard going forward.
Right. So it went from this dramatic armed robbery, masked man, a chase, to a quiet but profound revolution in how expert evidence, especially visual comparison evidence, is treated in Australian courtrooms. The mystery of who was behind the mask became this landmark case about the very definition of knowledge, of expertise in the eyes of the law.
Exactly. And the immediate personal impact for Anthony Honeysett was obviously huge. His conviction, which had been upheld by the NSWCCA, was suddenly quashed. He was granted the possibility of a new trial, and crucially, the key piece of evidence that the original jury had clearly focused on, the evidence the Crown themselves admitted was needed to carry the case forwards, was now ruled inadmissible, gone. This fundamentally changed the evidentiary landscape for any potential retrial.
And stepping back from the individual case, how did Honeysett VR actually reshape Australian legal practice more broadly? What's its lasting legacy, particularly concerning expert evidence under that Uniform Evidence Law?
Oh, its impact was profound, and it really continues to be felt across various fields of expert evidence. Firstly, and most fundamentally, it provided this crucial high-level clarification from the highest court on the meaning and application of specialized knowledge under Section 79. The High Court made it crystal clear. It's not enough for an expert to just walk in with an impressive CV with general qualifications in a field like anatomy or engineering or whatever it might be. Their specialized knowledge must be shown to be directly and reliably applicable to the specific opinion they're giving and the specific task they performed.
Like comparing masked people in bad video.
Exactly. The opinion must be demonstrably based on that verifiable knowledge, not just on the expert's subjective impression, their hunch, or their say-so. This really put the brakes on experts potentially offering opinions that were essentially just their personal belief, lacking a solid, reliable foundation linked to their actual expertise and validated methods. It limits the ipse dixit factor. Secondly, and very specifically, the case significantly raised the bar for admitting evidence based on subjective image comparison. This includes fields like facial mapping from CCTV, gait analysis identifying people by how they walk on video, or the kind of anatomical or morphological comparisons Professor Henneberg attempted. Experts in these areas can no longer rely solely on their years of experience or their simple assertion that, "I'm trained, I can see things you can't." They now have to clearly demonstrate, based on some reliable body of knowledge or a properly validated technique, how their specialized knowledge allows them to draw conclusions from the visual material that genuinely assists the court and go beyond what any ordinary layperson could reasonably observe or infer just by looking carefully.
So more rigor required.
Much more. Thirdly, while the High Court didn't definitively kill off the ad hoc expert concept entirely, because the Crown didn't push it, their very strict interpretation of Section 79 makes it highly questionable whether expertise supposedly gained just from looking intensely at the material in one specific case, without that strong connection to a reliable, validated body of knowledge, could ever qualify as specialized knowledge under the Act. The ruling strongly implies that experience needs to translate into demonstrably reliable knowledge that provides genuine, verifiable insight, not just familiarity. Fourthly, the decision powerfully reinforced the critical function of trial judges as gatekeepers of expert evidence. It's not just about letting evidence in if it seems relevant. Judges now have a clearer mandate to engage in rigorous scrutiny under Section 79. They can't just accept an expert's qualifications at face value. They need to actively examine the crucial link between those qualifications, the specific specialized knowledge being asserted, the methodology used to apply that knowledge, and the actual opinion being offered. There's a heavier burden on judges now to be actively satisfied that the evidence is genuinely based on reliable expertise applicable to the specific task, not just based on the expert's impressive credentials.
And finally, what about the impact on the lawyers arguing these cases?
It definitely changed the game for legal practitioners, too. For defense lawyers, Honeysett provided a much stronger foundation, a powerful tool to challenge expert opinions, especially in those fields sometimes seen as softer sciences or those lacking universally accepted standardized methodologies like image comparison. And conversely, it compelled prosecutors to be far more diligent. They now need to ensure that their experts' reports clearly and explicitly articulate the specific basis of their opinions in relation to their verifiable specialized knowledge. They need to demonstrate that the methodology used is reliable and actually applicable to the task at hand. Prosecutors have to be prepared to prove not just that their expert knows their general field, but that their knowledge and their method allow them to do this specific thing reliably and helpfully for the court.
So quite a shift in responsibility.
Yes. Ultimately, Honeysett VR really stands for a fundamental principle in the fair administration of justice. Expert evidence is there to genuinely help the jury or judge understand complex matters that are beyond ordinary common knowledge. But to do that helpfully and fairly, it must be based on sound, verifiable principles. It can't just be based on the authority or the title of the person giving it. It protects the integrity of the trial process by ensuring that evidence isn't just persuasive because of that potential white coat effect. The expert sounds impressive, so they must be right, but is actually reliable and properly grounded in genuine expertise applicable to the facts of the case.
So it's a gripping story, isn't it? Starts with a crime, masks a hammer, a getaway, and ends up reshaping the rules around courtroom expertise itself. It makes you really consider the immense power held by someone who steps into a courtroom and says, based on my specialized knowledge, this is what I see. And how absolutely crucial it is that the law demands a clear, verifiable, reliable basis for that power before it's allowed to influence something as important as a criminal verdict.
It's such a powerful reminder, I think, that even in our modern era, with all the advanced technology and complex forensic science we have, the fundamental rules of evidence are still vital. They're designed to ensure that what's presented to a jury isn't just a confident assertion, maybe based on subjective belief, but is actually reliable assistance grounded in demonstrable knowledge. The law, through cases like Honeysett, holds expertise to a necessarily high standard. It demands that its foundation is solid, transparent, and testable, not just based on someone's personal impression, however experienced they might seem.
A really complex journey, wasn't it? From that hotel lobby in Narrabeen, through the police investigation, the district court, the Court of Criminal Appeal, all the way to the High Court in Canberra, all to determine what really counts as knowledge when seeing through a mask, through a blurry camera lens, just isn't enough on its own. It certainly makes you pause and think, doesn't it, about the information we all receive every day from all sorts of experts, and the importance of sometimes asking, what's the actual foundation for that claim?
A very important question.
Well, thank you for joining us for this deep dive into the fascinating case of Honeysett VR. If this has sparked your interest in that complex intersection of science, perception, law, and evidence, there's always so much more to explore in the intricate workings of our legal system.